Thank you for choosing Think Outside the Globe as a source of continuing legal education training. It's my intent to present practical and experiential training for plaintiffs' attorneys that has been proven to create more scientific and less subjective testimony in products liability and organizational negligence litigation. Let's get started. This presentation is divided into logical sections. Because this material is a departure from typical forensic investigative methods, it's important that the participant be familiar with the foundational elements of the information. It's also vital to understand how the background of the author contributes to the unique approach to proving or disproving standard of care. My name is Tom Taormina. I'm a consulting and testifying expert witness. For 14 years, I worked at NASA's Mission Control Center in Houston. My career as a quality control engineer spanned the Gemini, Apollo, and Skylab programs. I was on duty for Apollo 13 and heard, "Houston, we have a problem," firsthand. I became a specialist in supplier quality. Over a decade, I performed assessment audits at hundreds of companies to determine if they were capable of supplying products and services to Mission Control. During the next 10 years, I ran 3 different manufacturing companies. My mission was to hold people accountable for their own work and ship defect-free products. I've been active with the American Society for Quality in pioneering proactive quality management. I contributed to the body of knowledge for the Certified Manager of Quality and Organizational Excellence, for which I've held certification since 1996. Over the last 27 years, I've been a business management consultant who has now worked with more than 700 companies. I have earned the Certified Management Consultant credential from the Institute of Management Consultants. For nearly 2 decades, I've been working as a consulting and testifying expert witness in products liability and organizational negligence. There's no listing in any referral service or expert directory for my area of expertise. My rich experience and training as a quality control engineer, business leader, and consultant have provided me with a unique set of tools as an expert witness. While other forensic experts are researching causes and origins, I study the defendant company and determine whether they did or did not exhibit an appropriate standard of care in delivering their products or services into the stream of commerce. We will discuss this methodology in detail during this presentation. In nearly 2 decades, I have never been the subject of a Daubert challenge, and my unique approach to expert testimony has never been successfully impugned by opposing counsel. During initial screening by a prospective litigator, explanation of my specialty and expertise invariably leads to the questioning, "Yes, but are you an expert in passenger tires, chainsaws, oxygen generators, electrical fires, or whatever the critical elements of the case involve?" My response is that the failure modality and causes are not what I do. While other qualified experts are performing their forensic investigations, my contribution is examining the defendant company's adherence to industry and other standards of quality, process conformance, and foreseeable risk. We'll discuss these differences and the collaborative power of what I bring to a litigation team in the remainder of this presentation. My experience is enclosed as a list of products and services that I have become functionally literate about in the course of my various careers. It's accurate to say that my investigation's successful reporting and testimony do not require me to be a subject matter expert for the plaintiff in the modality of failure of product or service. Finally, I'm a prolific author who is passionate about business excellence and risk avoidance. I was commissioned to write my 11th book, Foreseeable Risk, by Lawyers and Judges Publishing, as a reference book for litigators and as a roadmap for risk avoidance by enlightened business leaders. The title of my latest book, It Was Rocket Science, will give you an insight into the selection of the title of this presentation, Think Outside of the Globe. This in no way implies that I behave as an advocate, as an expert witness. The methods and case studies offered in this training are not presented as reference material for legal arguments. It must be noted I do not represent myself as an expert in product safety, but I do have extensive experience with compliance to safety standards among my working experience with other standards and regulations. In my archive of memorable products liability cases, there's one that I often cite anecdotally as the most prolific example of negligent standard of care by a defendant company. The plaintiff had purchased an inexpensive residential box fan. The brand name may be familiar, although the manufacturing facility that built the subject fan no longer exists. In the summer, the subject fan ran virtually continuously. One night, the switch that turned the fan on and off and controlled speed ignited to combustion temperature and started a fire that led to the death and critical injury of several family members. The basic design for the subject fan was from the mid-1960s. As the company passed from generation to generation, the new owners had to find ways to compete with similar products that were manufactured overseas. The short-term solution was to buy the motor and switch assembly in Asia. The C&O experts quickly determined that the motor and switch assembly did not meet the requirements of safety for electrical appliances sold in the U.S. The case might have moved to settlement based on their findings, but the defense counsel was a predatory advocate whose mission it was to avoid admitting liability. The focus of my investigation was the quality and business practices of the manufacturer and their control over their suppliers. Through discovery, I obtained copies of their quality assurance manual and operational procedures. I also obtained copies of their contract with the offshore supplier of the motor and switch. The quality manual was poorly drafted, and it was a representation of an internationally recognized quality system standard. My preliminary report concluded the manual and procedures were inadequate for the type of product they were manufacturing. Their documents did not meet the test of industry practices that would effectively prevent unsafe products from being sold. My conclusions were that the manufacturer did not exhibit an appropriate standard of care. This accident was foreseeable. As introduced earlier, I was a quality control engineer at NASA in Houston during the Gemini and Apollo programs. My expert was conducting audits of companies that were proposing to provide products or services for mission control. Over a decade, I conducted hundreds of capability audits. The potential suppliers knew that I was working from an out-of-date military quality standard and checklist. They were usually prepared with the requisite documents and records. After a few months, I discarded the checklist and performed comprehensive examinations that evaluated each step in their processes and how they were executed. NASA administration got some nasty phone calls about my reports, but my holistic process auditing methods were ultimately validated and became standard within our organization. I would learn later that the auditing style I introduced to compliance assessment was a forensic investigation of the organization as a living organism. I would document how their claims of quality and performance did or did not pass the scrutiny of them empirically demonstrating to me that they were healthy, viable, and robust. Our mission was simply to send men to the moon and return them home safely. That mission required more than a properly filled out quality checklist. Years later, an attorney called me and asked if I could do a quality audit on the defendant company in a products liability case. It involved defective material becoming a constituent part of critical products used in aerospace. Since aerospace was my background, this assignment was a logical fit. Over the last 2 decades, that request evolved into 12 books that codified my assessment and diagnostic methods. The foundation of my work is based on the truism that every activity, personal or professional, is a process. In business, every step performed by a manufacturing or service company has an input, an activity, and a measurable outcome. The deliverable products or services, then, are the result of effectiveness of how the processes work and how they complement each other. At NASA, we discovered that successful space missions were dependent on precisely managing hundreds of interrelated processes that were dependent on each other for mission success. As we evolved the discipline of quality systems management, we found that removing foreseeable risk was the only solution to error-proofing each constituent component of space science. We also became acutely aware of the differences between assumed risk and foreseeable risk. The Apollo 1 launch pad fire was unforeseeable because there were so many new systems being tested at one time. The Challenger disaster, however, was foreseeable because the mission was launched in temperatures below the mandated safety parameters. The graphic on this slide represents the version of process control we have found to be most effective in my 50 years of experience. It can also be used to locate failures in process efficacy and in locating root causes of process breakdowns. For me, the segue from quality systems auditing to proving or disproving standard of care was crystal clear. In my experts' reports, I typically include a statement such as, "The failure was the result of a series of seemingly unrelated activities that manifested themselves in a catastrophic event." The most common modality for that convergence of events to happen is for negligence by the defendant in following standards, procedures, and their own requirements. In many cases, there is carelessness by the defendant to fully follow industry, quality, and their own standards. In all too many other cases I've worked, defendant companies create risk by striving for higher profits by lowering their standards of conformance and performance. In another watershed case, a defendant stated the nature of their product had an acceptable kill rate each year. That depot page is contained in my expert witness Hall of Shame. Present-day offshoring manufacturing is another of the most egregious approaches to increasing profits and introducing foreseeable risk. Not only does the organization that places the product in the stream of commerce not have control over the quality and safety of the products they import, shadow supply chain management often makes it impossible to determine who made the product. In cases involving offshore products or manufacturing, our quality assurance training and supply chain experience has successfully made the argument that the company that sold the product cannot abdicate their accountability for conformance and safety to a supplier that cannot readily be subject to our civil laws. By the way, there are credible offshore suppliers and manufacturers. I helped Dell Computer write their supply chain quality manual. I have first-hand knowledge that offshore manufacturers can deliver reliable products and that they can be held accountable for their actions. In my consulting work, I stress these differences to those who are considering offshoring. As an expert witness, I use these experiences to effectively contradict defense testimony that they had little control in management of the quality and safety of their offshore suppliers. In the Fan case discussed earlier, my preliminary report created a heated and confrontational response from defense counsel. The rebuttal did not address my issues of unacceptable standard of care. The motor and switch had Underwriters Laboratories markings, suggested that they were safety tested, and that the motor had a QC accepted sticker on it. Unfortunately, the contract with the offshore manufacturer, obtained through discovery, specified requirements that were among the most egregious that I have ever encountered. The contract specified that the manufacturer would place the UL-RU markings, indicating they were components tested by UL. The contract also required a QC accepted sticker placed on the motor. There was, however, no requirement that the components were actually tested, inspected, or certified. The document went on to state that there was a known high rate of failure of the components, and the offshore supplier would deliver a significant quantity of spare motors and switches to compensate for the ones that would fail during product testing. My findings went before the judge, and we were given permission to perform a factory inspection to validate my opinions and conclusions. The audit revealed the most blatant lack of standard of care I have ever witnessed. The fans were built on a conveyor system. Those that did not pass final test were put on carts. Each afternoon, production would stop, the defective fans returned to the line, and new motors were installed until the fan passed the basic operational test. The outcome of my final report led to a substantial award for the plaintiffs, and the plant eventually closed and moved manufacturing offshore. Duty of care and standard of care are typically subjective, and introducing them as a strategy can be very expensive and time-consuming. The outcome is typically 2 or more qualified experts testifying for and against, resulting in conflicting opinions. The prevailing argument is often the result of which expert was the most convincing. Attorneys who are looking for out-of-the-box strategies are pioneers in seeking out new techniques. In this case, I challenge litigators to think outside the globe, as we did when we won the space race. To begin the journey of thinking outside the globe, we'll delve into the tenets of my methods. There are no expert witness directories listings for process controls experts, at least not in my experiences. The concepts are documented in my books and validated by my successes as an expert. As demonstrated above, working for the plaintiff, judges have allowed me to perform physical audits of the defendant's manufacturing operation to determine conformance to standards and procedures. Defense counsel has always been antagonistic, but it has taken me to places like Mexico City and Shanghai. The My Cousin Vinny graphic on a previous slide represents my impression of defense counsel expressing, "You was serious about that?" My expert methodology is a derivative of quality management system auditing. Quality control, quality assurance, and quality management are seldom in the lexicon of litigators. Their role in case strategy is even more obtuse. There are very few quality experts listed by the expert placement services, and what they can contribute is not well understood. Reporting and testifying in quality babble is as damaging to a case as experts who testify in technobabble. The strategy proposed in this training is for litigators to familiarize themselves with the process controls and quality management at a layman's level. As depicted in this slide, the quality profession itself is vested in complex statistics and punitive methods for conformance control. My successes are based on being a business person first, a process expert, and a student of how organizations fail to adhere to their own standards. I have never been vested in quality babble. I speak to the logical steps of how a product or service is produced and how it can fail when used appropriately or inappropriately by a consumer. My investigations provide a roadmap that's a logical storyline of the events leading to unraveling the tangled web of how the failure was the result of a series of seemingly unrelated activities that manifested themselves in a catastrophic event. As evidence unfolds, the focus of my investigations shifts to the various elements of negligence or dereliction of duty. That is typically presented in tables of rows and columns that are logical, provable, and understandable. I weave a tapestry of how these seemingly minor infractions ultimately led to catastrophe. The exemplar exhibit on this slide is the foundation of how I establish duty of care, define standard of care, and scientifically prove acceptable or negligent standard of care by the defendant. In the context of products liability and organizational negligence, it's defensible to make the analogy suggested earlier that companies are living organisms. They're complex systems of interrelated parts. The various elements are continually changing, growing, or dying. There are healthy organizations. There are organizations that have specific departments that have known or undiagnosed diseases. There are organizations that are terminally ill. The forensic science presented herein examines the pathology of defendant organizations and reports its findings in forensic diagnoses. Continuing the metaphor, it can be argued that duty of care for a human is to maintain one's health, live by the rule of law, and do no harm to others. For defendants, defining a duty of care is often highly ambiguous. However, when duty of care is clearly defined in a statute with quantifiable parameters, obligatory diligence can be relatively straightforward. When duty of care has accepted standards established, such as in pharma or food safety, applying these standards can also be used to rebut claims that are not based in empirical data. In cases where industry standards exist, experts can create compliance matrices to commonly acceptable industry practices. Where standards or peer-accepted bodies of knowledge do not exist, our methodology successfully cites the international standards of quality to create scientific basis for duty of care. The definition of standard of care also contains obtuse terminology such as dependent on circumstances and a reasonable person. Obviously, there are volumes of case law that are used to establish precedents for comparison. Some are spot on and unambiguous. Many are subject to the persuasiveness of those proposing the interpretation. In our investigations, compliance and standard of care is directly measurable against the duty of care we established by our research. Forensic quality systems audits can be and have been used as scientific proof of standard of care. When cogent standards for duty of care are either non-existent or there's conflicting peer-accepted data, the international quality standard ISO 9001 can be used as the benchmark for establishing duty of care. It was first implemented in 1987 by the EU to standardize minimum acceptable quality requirements across languages, cultures, and industries. It's continually updated and maintained as compliance audit outcomes set precedents across industries. The more compliance audits that are performed, the knowledge base creates an ever more effective basis for comparison similar to case law. ISO 9001 has been adopted in more than 150 countries. It is the de facto standard for minimally acceptable quality practices that responsible manufacturing and service companies should maintain. It has set a global precedent for industry standardization, as there are now thousands of similar non-binding standards published that establish benchmarks for compliance in a vast number of industries. Many thousands of organizations worldwide have elected to have their quality management systems certified by independent and accredited registrars. This is accomplished by third-party audits to establish certification and follow-up with periodic compliance audits. Certification is like obtaining a driver's license. You demonstrate that, in one moment of time, you understood the rules and were able to convince an examiner of your basic proficiency. Also, like a driver's license, periodic renewals occur to ensure ongoing compliance. For the quality standard ISO 9001, organizations are subject to periodic sampling audits that demonstrate ongoing compliance and continual improvement of their processes. By becoming certified, companies are bound to comply with the tenets of the standard, making it the defined duty of care for those companies. Since ISO 9001 is globally recognized, companies that do not seek formal certification for their organization can still be compared to the standards for reasonable and prudent quality practices. In my 50 years of experience working with more than 700 companies, documented in 12 books, I have created a knowledge base of how ISO 9001 can be used as a comprehensive organizational management system. I implemented this methodology on a large scale at Dell Computer. It was designed as a business management system instead of a quality management system. Dell has amassed quantitative data on the effectiveness of this methodology which is part of the foundation for my work as a consultant and as an expert. I use these success stories to establish a baseline profile of a successful company that takes great care in producing safe and reliable products. I use absence of diligence in specific organizational operations and processes to impugn the standard of care exhibited by defendants. Litigators who think outside the globe can now employ this proven model based on science and history to make more compelling case for the plaintiff. This flowchart represents the typical execution of our investigative methodology. It forensically executes commonly accepted practices of effective process assessments. Now, let's move from foundation and history to practical applications for you and your practice. I recommend that before opening a case file and collecting detailed evidence, do a preliminary research on the defendant company. Independently or with our help, search the internet for articles, news reports, web pages, sales literature, and any other anecdotal information you can find. Organizations often have a compelling and revealing data embedded in their web and social media. Most company websites are designed by marketing people who often make misleading and erroneous claims. Expression of customer experiences with a company can also provide anecdotal information that leads to rapidly uncovering a bad actor. If you're ready to take the next step in thinking outside the globe, engage us to perform a preliminary forensic evaluation of the defendant company. It's conducted using the filings and responses in any production already available. We present data based on research about the company from the perspective of quality management and safety performance. Preliminary conclusions and opinions give you a foundation for your strategy and what other experts may or may not be needed. It can create more focused discovery requests that reveal documentation of the defendant company to standards. There is a history of our preliminary reports leading to early case settlements. The expense is minimal compared to hiring the wrong experts or spending time and resources for unnecessary forensic investigations. The following testimonial is from attorney Sid Leach, a partner at the law firm of Snell and Wilmer in their Phoenix office. His background is contained in the slide deck.
I have known Tom Taormina and worked with him in various capacities for 40 years. As his career has progressed, I've witnessed his development of impressive process control and quality management techniques. He is a prolific writer. He has published 12 books that reflect his expertise in how organizations either create viable products and services or ignore the warning signs of foreseeable risk. He appears to have a novel approach to holistic assessment of an organization to determine appropriate standard of care. In 2012, I referred Tom to one of the litigators in my law firm as an expert witness. His expert report apparently was compelling enough to have the case settle while he was waiting in our office to be deposed. The CLE training course Tom has developed on this topic is very interesting. He's taken the experiences he lived during Project Apollo and created a foundation for defining standard of care in more scientific terms. In his consulting work, he's good at assessing the pathology of organizations. Tom has impressive credentials, and he has a good track record as a testifying expert witness. I recommend Tom and believe he can be a significant asset to litigators.
After assessment of the preliminary expert report, we recommend that the attorney base their case strategy on how relevant standard of care may be to a swift and positive outcome. We don't impose our methodology as a case strategy, only as a complement to the successful tactics created by our attorney clients. Our investigation can be key to proving negligent standard of care with virtually unimpeachable testimony. In complex cases, we use our proprietary forensic business pathology risk assessment tool, to quantify compliance and liability. In all cases, the 7 constituents of the graphic flow are examined for efficacy and standard of care. This investigated methodology had its foundation in quality management for Project Apollo. It has been refined over decades to provide a complete picture of accountability and vitality of virtually any organization. The risk index is also used in consulting to help organizations evaluate their viability in the marketplace and for assessing foreseeable risk. Typically, further investigation is conducted by providing counsel with a list of required discovery. It contains very specific questions relating to quality management, supply chain management, standards, testing, safety conformance, manufacturing processes, and foreseeable risk. If discovery is provided, there are often nonconformities to the company's own procedures that make a case for negligence. If discovery is withheld or redacted, there is significant precedence in the discipline of quality management that states that lack of proper documentation is grounds for proving nonconformity. If the defendant company is certified to ISO 9001, I have extensive experience, documented in 10 books, that there is yet to be a company I have examined that does not exhibit multiple critical deviations to the requirements of the standard. This ability is not about my investigative prowess. It's the result of organizations becoming lax in following their own procedures. There is ample documented history of companies writing too many procedures that are often circumvented or ignored. In constructing any necessary subsequent revisions to the expert report, research and discovery are used to create a narrative that takes the reader on a clearly and concisely worded journey that establishes how, quote, the failure was the result of a series of seemingly unrelated activities that manifested themselves in a catastrophic event, unquote. A scientific and credible case is made for how the defendant had a duty to identify foreseeable risk. Conclusions tie together the work of other forensic experts that validate the failure modes were directly the result of lack of appropriate standard of care. The expert opinion offered is based on internationally accepted documented quality management conventions, not merely my expert opinion based on experience. In my experience, opposing counsel is still struggling with understanding the context and gravity of my reports at time of deposition. In one case, the defense hired 3 quality experts in a row who attempted to rebut my report. 2 were unsuccessful as I discredited their arguments. The third refused to be deposed because he had no valid arguments with my report. My depositions typically last an hour or two if opposing counsel finds themselves ill-prepared to depose me, or they see the futility of embarrassing themselves with continuing the depo. Other depositions have run into multiple days when opposing counsel is determined to maneuver me into contradicting myself or testifying outside my area of expertise. As asserted earlier, 82% of my cases settle after my report or after deposition. Plaintiffs' attorneys who think outside the globe and focused on my proof of inappropriate standard of care prevail more often and with more favorable outcomes for their clients. This statement is very subjective because I'm seldom privy to the settlement terms, but plaintiffs' counsel usually effectively signals their client's satisfaction with the outcome. The following 4 slides are based on my experiences and issues that have been successfully argued and those that can be impeached. Consumers can invariably find ways of using a product or service incorrectly or unsafely. Within the definition of duty of care, however, there must be established or referenced standards that result in product use, instructions, and warnings that cover foreseeable risk. Defendants cannot abdicate their accountability for safety. It can also be successfully argued that plaintiffs cannot be impugned for using an unsafe product that did not include appropriate instructions or warnings. Defective products that cause harm are typically the result of negligence on the part of the defendant, not the plaintiff. Within the processes and systems of the defendant company, there can typically be found areas of standard of care that is specified and documented, but design and manufacture is shortcut, bypassed, or otherwise neglected to follow their own procedures. The organization that introduces the product or service into the stream of commerce cannot abdicate their accountability for safety and reliability to a subcontractor or supplier. International quality standards provide guidance in the form of supply chain management tenets that can be used to prove that the defendant is strictly liable for the products they sell. Proving joint, several, and vicarious liability is a slippery slope when there are quality and safety standards that can be successfully argued. Product safety listings and marks, such as UL, CSA, or EU, can no longer give assurance of their intended verification or safety testing. When organizations such as Underwriters Laboratories were formed to test for product safety, the manufacturer was ethically bound to conduct exhaustive safety testing and then supply samples to UL for testing and certification. That entire process has been compromised by companies that do minimal safety testing to save expense and then send samples to UL for them to discover inherent safety issues for them. During my 50-year career, I've witnessed the early days when UL had one attorney on retainer. Now they have a cadre of defense attorneys refuting arguments that UL did not due diligence in testing and certifying a product. To exacerbate the problem, offshore testing agencies and UL contractors do not adhere to the same diligence in testing as required for U.S. consumers. I was auditing a maquiladora in Mexico at the same time as the UL contractor was on site for their periodic conformance audit. According to the guest log, the auditor was on site for 35 minutes to audit a company with more than 1,200 UL listed products. Large chain and box stores concoct a politically convenient rationale for compromising quality and safety in favor of low prices. Voracious business leaders do make dissolute decisions to sell potentially dangerous products by overlooking the risks of buying and selling products in large quantities, where there are limited toll gates in place to assure safety and quality. Again, importers and those that use offshore manufacturing often intentionally do not perform due diligence in invoking contractual safety and quality requirements. There are ample guidelines and case studies in supply chain quality management to cogently argue lack of reasonable and prudent control by the defendant. In my litigation experience and in working with bulk fulfillment companies and call centers, there's a vicarious business model that argues that the consumer does not have to return a defective product to get a replacement or a refund. In quality parlance, that policy means that companies are avoiding doing failure mode analysis on their products, leading to the defendant being tacitly unaware of unsafe or unreliable products. As they say in Texas, that dog don't hunt. With rapidly changing technology and software, another absurd argument can be made that products have such a short lifespan that exhaustive testing is impossible or limited. It's egregious enough that the business tactic causes consumers constant frustration with defective products that they discard. It is not, however, a viable basis for arguing lack of foreseeable risk. As discussed previously, conformance and safety cannot be inspected or tested into a product. Unfortunately, purchasing a product with the logo of a certified testing agency is no longer a guarantee of inherent safety and quality. As represented in the case studies later in this presentation, not only is there extensive case law on specified and implied instructions and warnings, there are experts who will testify to the degree of accountability that can be placed with the plaintiff. In our current culture, inherently dangerous products should have extensive warnings and safety measures to stupid-proof the products. As with safety testing companies, the Consumer Product Safety Commission cannot be the gatekeeper for preventing defective products from reaching the consumer. In my extensive experience, it's impossible to foresee every possible dangerous scenario that a customer may encounter or cause. The automobile industry uses documented design failure mode analysis, or DFMA, and product failure mode analysis, PFMA, tools to predict products' defects and potential failures. These extensive and costly measures obviously are not sufficient to prevent the many minor and major recalls that have happened over the years. As with the argument that usable life of a product prevents adequate testing, stipulating that breakthroughs in science and technologies that produce safer products are imminent does not absolve a company from their duty of care. In my extensive work with standards and compliance issues, companies that use constrictive regulation as an excuse for vicarious liability do not have a viable argument. Standards, regulations, laws, and statutes are in place because there's a history of abuse or inadequate standard of care. In my consulting work, I teach standards as a profit center, where compliance is built into a product or service in the usual conduct of business. Finding the reason for existence of standards can be turned into a marketing advantage instead of an overhead cost or an ineffective argument for non-compliance. Cases I work seldom go to trial. When they do, lead counsel crafts their case around the negligence of the defendant and then validates the forensic findings with my testimony. The following is a sampling of case studies that speak to the efficacy of thinking outside the globe. They're based on actual cases, redacted and dramatized to maintain confidentiality when the outcome is not public record. In each case, the litigator retained qualified C&O experts to provide forensic opinions as to failure mode and cause. We collaborate with other experts to share findings and add validity to failure mode analysis. Our mantra of Think Outside the Globe offers alternative strategies for litigators who are expert in uncovering a smoking gun. Investigators traced the cause of a house fire that killed several people to a portable space heater. The internal temperatures of space heaters are at or just below ignition temperatures of fabrics and other household items. There are mandated safety devices to turn the heater off if it is tipped over, but there is no safety device to ensure common sense use by the customer. The C&O forensic investigators discovered that the plastic used for the outer housing was not the required grade of plastic that would contain sparks or potential ignition of the heater. Even though the product, manufactured in Asia, had a UL safety listing, the manufacturer was able to use inferior plastic without challenge by the Asian testing agency. Our investigation revealed the space heater had the brand name of an American company. Attempting to trace the actual location it was manufactured was obfuscated by a quagmire of holding companies, importers, multiple factories that made similar products. Our investigation was unable to locate the UL testing records or any documentation on the defective heater. If there were any, the records had been successfully hidden by the evolving chain of custody. Organizations that choose to outsource the entire manufacture of their products sometimes ignore the potential risk of lack of first-hand control. Some intentionally build in plausible deniability of how the product was manufactured. Others are just naive in assuming their products will be assembled and tested to the same standards as they are in the U.S. Unfortunately, more current versions of the American brand heater are still for sale in the retail market. The outcome of this case was in favor of the plaintiff, but very expensive to litigate. Hospital personnel were unable to revive a young girl who was administered an incorrect intravenous medication. The youngster was admitted with breathing problems and an IV was ordered for a medicine that was designed to relieve her congestion. The hospital pharmacy dispensed a medication that had a very similar name but was formulated to induce coma in seriously injured adult patients. The plaintiff's family filed actions against the hospital and against the manufacturer of the automated dispensing machine that was used to fill the prescription. It was alleged that both were negligent in wrong drug being used to administer to their child. The hospital obviously had the strict liability due to human error, but the machine manufacturer denied any liability. Our investigation of the manufacture of the automated dispensing machine revealed that the company had been aware that there were drugs named so similarly that there was the possibility of dispensing the wrong drug due to operator error. The manufacturer was found to have exhibited inappropriate standard of care in ensuring that their machine could have contributed to the mistake and death. Standard of care requires the manufacturer to search for every discoverable opportunity for foreseeable risks in their products and manufacturing techniques. In this case, the machine manufacturer knew of the possibility of misuse, but did not take appropriate steps to make their customers aware of uncommon issues. Both parties were held liable. Two avid female golfers were playing a very hilly golf course. They had rented a golf cart from the clubhouse and were enjoying their play. Traversing a very hilly path, the passenger was thrown from the cart and sustained major injury to her spine and hips. Detailed investigation of golf carts, in general, revealed some disturbing facts. The side handles are very small and recessed so that golfers can slide in and out of the seat easily. There are no safety belts. There are no handles or grabs on the dash or the canopy structure. While carts have a governed maximum speed, it does not take into consideration steep terrain. In this model, what limited safety warnings provided were hidden underneath the place where the scorecard is retained. The passenger was only 5 feet tall. Our investigation revealed there was absolutely nothing she could hold on to as they traversed the hilly course. In deposition, the manufacturer represented that they had to design golf carts for large and tall people to easily slide in and out. They claimed that golfers would not wear seat belts and that they saw no need for any handles or grips. The most shocking testimony was that the company had a long history of defending lawsuits from individuals who were injured using their products. In fact, they had a line item in their budget to cover lawsuits. Unfortunately, all too many organizations build into their budgets the cost of defending lawsuits. Some have operational philosophy that includes that they will routinely injure users in the normal use of their product. It's common folklore that products will always have a certain failure rate that is acceptable and unavoidable. Regardless, for plaintiffs, there are discoverable industry and quality standards that can be successfully argued as the basis for defendant negligence. This case settled after the damning statements provided by their quality manager of an acceptable injury rate. A family purchased an artificial Christmas tree from a major retailer. The tree was pre-lit, meaning that it had festive lights pre-wired into the branches. In the plaintiff's home, the tree was left on overnight. Parts of the wiring that were poorly assembled caused overheating and a resulting fire. 2 youngsters perished in the fire. The electrical experts traced the origin to electrical connections that did not completely capture the wire inside the lamp sockets. The intermittent connection caused the contacts to get hot until they finally reached combustion temperature. The retailer claimed that they import thousands of these trees from brokers who get them from a long list of manufacturers in Asia. According to their testimony, there was no way for them to do quality control inspections on all the electrical products they sold, especially seasonal items like Christmas trees. It was our testimony that all electrical appliances sold in the United States must undergo safety testing prior to being offered for sale. For decades, Underwriters Laboratories has been the most trusted name in product safety testing. Each product must contain a UL listing number that can be used to trace the product back to its initial safety testing. While these trees had UL listing numbers, they may or may not have been subject to the rigorous scrutiny UL is famous for because they use contract agencies outside the U.S. The product went through so many distribution and warehouse facilities it was virtually impossible to trace it back to the certifying agency in China. The large retailer was so well positioned with intermediate organizations that their attorneys successfully had them dismissed from the case. It's the responsibility of the plaintiff's attorney to factor this scenario in how a case is litigated. An undisclosed settlement was reached in favor of the plaintiff. A youngster was electrocuted while attempting to charge the battery on his go-kart. The battery charger was very old and in poor repair. The boy was barefoot and the grassy field around the go-kart was saturated from a recent rainstorm. The extension cords the boy used to reach the nearest outlet had the ground pin cut off because older home only had two-prong, non-polarized receptacles. The forensic investigators for the defense developed a body of evidence that they were certain would prove total negligence by the plaintiff and his family that led to his death. The forensic experts for the plaintiff discovered a frayed wire inside the battery charger that, with time and improper manufacturing, caused the metal case and handle of the battery charger to be live with 120-volt house current rather than grounded or neutral. Our investigation of the manufacturing techniques used by the old battery charger were substandard, and there were many opportunities for the wires to become abraded and contact other metal objects inside the unit. Further investigation of the current version of the model battery charger had a plastic coating on the handle, and the wiring was bundled and immobilized from moving or abrading during normal use. The defendant was obviously aware of the shock hazard. Thinking outside the globe, the argument was successfully made that the manufacturer had a standard of care to search for every potential opportunity for foreseeable risk in their products and manufacturing techniques, and to take proactive measures to ensure safety during normal use. The fact that the product was old, the child unsupervised, and the environment invited misuse did not prevail in the outcome. I offer the following conclusions based solely on my personal experience. Products liability, personal injury, and organizational negligence tort is almost never a slam dunk outcome. A preponderance of forensic evidence does not always reveal underlying cause of the accident. The side that prevails is frequently the one that has the most believable story or the one with the most charismatic witnesses. Regardless of the credentials of an expert witness, our efficacy is dependent on how compelling our evidence is and how convincingly we deliver it in terms understandable to the layman. Our model has proven to replace arguable opinions with more scientifically derived analyses of the standard of care exhibited by the defendant organization. Opposing counsel is often ill-prepared to assimilate the content of our context of our reports. There's a very small pool of experts who are credentialed and able to rebut our reports. Deposition of our investigation places defense counsel in a difficult position of refuting testimony that is typically outside their wheelhouse. Court testimony of our investigation often gets the undivided attention of the judge and jury as if they were witnessing a compelling crime drama show. Thinking outside the globe can provide a clear strategic advantage for litigators. I hope you found this courseware stimulating and educational. It's offered to present alternative approaches to litigating products liability, personal injury, and organizational negligence cases. The author also suggests including these strategies and methods be used early in a case to avoid unnecessary experts being retained to provide confusing and confounding testimony. I'll be happy to provide clarification, answer questions, or give a preliminary review of a particular case. My contact information is included in the slide deck. I look forward to hearing from you.